Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2 of Jefferson County. You've been summoned here for what we call an arraignment. And what the arraignment is an opportunity for the court to inform you as to what you've been charged with, what your rights are, and what your options are concerning your case. The case or cases that you have in this court are what we call misdemeanors. We handle Class A or Class B and Class B misdemeanors. There are 3 types of misdemeanors. There's A, B, and C misdemeanors. The C misdemeanors are normally those cases that are handled in the justice court, what we call the JP court, or the municipal court, city court. The range of punishment for those Class C misdemeanors are fine only. So basically, you can not be sent to jail, punished to jail on a Class C misdemeanor. So your punishment will be by fine only. However, for a Class A or Class B misdemeanor, your punishment can include jail time. If you have a Class A misdemeanor, the range of punishment is confinement in the county jail for a term not to exceed 1 year or 365 days, a fine not to exceed $4,000, or you could be given both such fine and confinement. Now, you could be given jail time anywhere in between the 1 day and the 365, or the 0 days and the 365 days, or you could be given a fine anywhere from $0 all the way on up to $4,000, anywhere in between that. Or you could be given both such fine and confinement for a Class A misdemeanor. For a Class B misdemeanor, the range of punishment, confinement in the county jail for a term not to exceed 180 days, a fine not to exceed $2,000, or you could be given both such fine and confinement. And obviously, your jail time could be anywhere from 0 days all the way on up to 180 days. Fine is anywhere from $0 all the way on up to $2,000, or you could be given both such fine and confinement. As a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. If you want to hire an attorney, your case will be reset to give you time to hire that attorney. If you have already hired an attorney, please inform the court the name of the attorney, and that attorney will be contacted and your case will be reset. If you want to apply for a court-appointed attorney, you would be required to fill out a financial questionnaire so that we can determine whether or not you qualify for the appointment of a court-appointed attorney. Now, if you already have a court-appointed attorney, then please inform the court the name of the court-appointed attorney. We will contact that attorney, and your case will be reset. If you want to represent yourself, and if you waive your right to an attorney and represent yourself, please inform the court that that is your desire. You also have a right to have a trial by jury. And what a trial by jury means, it means that because this is misdemeanor court, 6 individuals will be selected to sit on your jury, and they'll decide whether or not to find you guilty or not guilty after listening to all the evidence. You have a right to waive or give up your right to have a trial by jury as well. And by doing so, your case can come before the court either by a jury trial, or it can come before the court by a plea, or it can come before the court by what we call an unagreed plea, where you don't have an agreement with the state. You also have a right to see the evidence that the state has against you. We call that discovery. You have a right to see that evidence. If you desire to see the state's evidence, then the state would allow you to have access to that evidence. If you desire not to have discovery and see the state's evidence, then you can waive or give up that right to see the state's evidence. If you're representing yourself, or if you have an attorney, and if you or your attorney, those of you who have an attorney, reach an agreement with the state to settle your case, we call that a plea bargain agreement. If you are able to reach a plea bargain agreement, the court, meaning the judge, does not have to follow that agreement. However, if the judge does not follow that plea bargain agreement, you'll be entitled to withdraw, which means you'll be entitled to take back your plea. However, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, you would have to first get permission from the judge to appeal your case. And what an appeal is, you'll be asking a higher court to review your case to see whether or not the court has committed an error by convicting you, or whether or not you were wrongfully convicted. That higher court is located right above this court. It's called the Ninth Court of Appeals. They will review your case, and they could either grant or deny your appeal. If they grant your appeal, they can find you not guilty, or if they grant your appeal, they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then within 30 days of them denying your appeal, you'll have a right to file a pro se petition for discretionary review. And what that basically means, you can appeal it to a higher court than the Ninth Court of Appeals. That higher court is located in Austin, Texas. It's called the Texas Court of Criminal Appeals. It's the highest criminal court in the state of Texas. And as I said earlier, you'll be filing what is called a pro se petition for discretionary review. Now, pro se means you'll be filing this without an attorney. You'll be representing yourself. And you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not you was wrongfully convicted, whether or not an error was committed, whether or not your appeal should have been granted. And they can either deny or grant your petition. If they grant your petition, they can find you not guilty, or they can send the case back down to this court, order this court to give you a whole new trial. If they deny your petition, then at that point, your conviction will stand. Now, everyone, each one of you have been arrested on your case or cases. And every day that you spent in jail on your case, until you bonded out, you could get credit on that toward your punishment. So for example, if you have, say, spent 5 days in jail, the state is offering you 5 days in jail. That simply means that if they give you credit for the time that you spent in jail, then you would not have to serve any more time in jail because you'll be given what is called credit for time served. So also, if they are if they're offering you a fine plus court costs, now every day that you spent in jail, you get credit at $100 per day. So for example, if they offer you a fine and court costs of $500, you spent 5 days in jail, you would not have to pay anything. Why? If they give you credit for it, because you spent 5 days in jail and you have $500 credit toward your punishment. Also, you'll have an option for those of you who who are representing yourself. You'll have an option to, or even if you're represented by an attorney, you'll have an option to enter one of three types of pleas. You could plead not guilty, which means that you're telling the court you did not commit the offense that you've been charged with, or you can plead guilty, which means you're telling the court that you committed the offense that you've been charged with, or you can plead no contest, which means you're telling the court that you would not be fighting or you will not be contesting those charges. Now, I mentioned that the range of punishment includes a fine, jail time, or jail time and a fine. Now, your punishment could be probation. There are two types of probation. One type of probation is called adjudicated probation. We normally refer to it as regular probation. The other type of probation is called unadjudicated probation. We normally refer to that as deferred adjudicated probation. Now, the difference between the two is as follows. With the adjudicated or regular probation, it does result in a conviction on your record. However, there's something that is called judicial clemency, whereby the court can set the conviction aside. Now, in order for that to happen, first, a person has to successfully complete the probation. The probation has to expire, cannot have any more time left on the probation, and the court has to discharge that person off of the probation. And if those things happen, then the court can set aside any complaint, affidavit, or information that has been filed, and then the court can set aside the conviction, which means that person would not have a conviction. However, if the person gets a subsequent conviction, a conviction later on, then the court can revive, resurrect, or bring back up this charge that it got judicial clemency on, and it could be used against them. And if they try to get a license from CPS could deny giving them a license, or if they have a license, that license can be revoked or suspended. Now, with the deferred probation or the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the unadjudicated probation, your case will be dismissed. It will not result in a conviction on your record, and you may qualify for what we call a non-disclosure, where we can't disclose to the public the fact that you were on deferred adjudication. However, if you violate the terms and conditions of your probation, the state can file a motion to revoke your probation, your unadjudicated probation. And if they do so, you can be arrested, brought back into court. You have a right to have a hearing. And if the judge determines at the hearing that you have violated your unadjudicated probation, the court can revoke your unadjudicated probation and give you a conviction. And if that happens, if your unadjudicated probation is revoked and you are given a conviction, obviously your case will not be dismissed and you cannot qualify for a non-disclosure. Now, going back to the punishment, I said that it either could be, or it still would continue with the punishment, if you have a fine or jail time. Now, if you have a fine, they can offer you to pay the fine. Now, if you can't pay the fine that day, then we can put you on a payment plan to pay it off. So much per month. Now, let's say you cannot pay off the fine at all. Then what can happen is the court can convert your fine to community service. In essence, you will do community service to work off your fine. Now, every hour that you do in community service, it counts as $12.50 towards your fine. It's like working for $12.50. Now, if there are some programs that this court have, and there are some programs that the state has. The state has a program that is called pretrial diversion. Pretrial diversion is a program through, when I say the state, I'm talking about the Jefferson County District Attorney's Office. They have a program normally for first-time offenders, people who have not been in trouble before. And this program, if the person is allowed into the program, complete the program, the case is dismissed. The way you get into the program, you have to have an attorney to help to file the application on your behalf. The offense that you charge with cannot be one of unlawfully carrying a weapon or resisting arrest. And you cannot have, like I say, a long criminal. You can't have a criminal history. It's usually for first-time offenders. If you get into the program, case is dismissed, you complete the program, you can get your case expunged from your record. Expunged means wiped off, deleted, or erased from your criminal record. That's through pretrial diversion. Now, if you are a veteran of any one of the branches of the military, Jefferson County District Attorney's Office has a program that is called Veterans Court. It's part of the pretrial diversion program. So you get into the program, complete the program, case is dismissed, you can get this case expunged from your record. Now, this court, County Court at Law number 2, has a program that is called a CSI program. It's a program that I started within the first 3 months of being here on the bench. And that program, CSI, stands for Community Safety Initiative. It's a program that is designed to make Jefferson County a safer place for all of us to work, live, raise our families, go to school, go to church. And the way the program works is we have partnerships with various agencies in the Jefferson County community, or the Jefferson County, in Jefferson County, Texas. And we have a program to address specific issues. For example, we have a partnership with Spindletop MHMR, Spindletop Mental Health Facility. They also have drug treatment. So if anyone has a mental health issue, then we can address that issue. We have individuals in the court who come to court to help do private interviews, assessments, and then develop a treatment plan, either outpatient or inpatient. If you have an issue with alcohol or drugs, if you're 21 years or younger, we have the ATAR program through Spindletop, or if you we have what is called OZAR, it's our local drug and alcohol council that can provide treatment as well. And what they would do is provide screenings, an interview, a screening, and develop a treatment plan, either outpatient or inpatient treatment plan. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program. So individuals who are in the program, they are trained in the hotel industry or the shipping industry or the chemical industry. And once they receive the training in those areas, then CICE will help them, assist them in getting employment in the field that they're trained in. We also, for individuals who have not finished high school and they want to get you want to get your high school diploma, CICE has a GED program, as well as Spindletop has a GED program. So they can assist you in getting your GED. Now, the reason why I brought that program up is because all of those programs can be used as community service. So for example, let's say you are in a job training program, and every hour that you spend in class, it would count as an hour toward community service, plus it will be considered $12.50 that's going toward your fine and court costs. So you're killing 3 birds with 1 stone. You're paying your fine and court costs, you're doing your community service, and you're in that program. So you're doing 3 things. You're doing 1 thing, but you're getting credit for 3 things. And now let me tell you this. The other part of the program, that all of the programs that I just spoke of through our CSI program, they are free. It doesn't cost you anything. You don't have to pay anything to enroll. Only thing you have to have is a desire to be in the program. And as I said, in Jefferson County, well, in County Court at Law number 2, we don't have court as usual. We have unusual court. And the reason why I say that is not because we are different, but it's because we're trying to make a difference in the lives of the individuals that come before this court, and we're trying to make a difference in Jefferson County. And the way we do it is by producing productive people. If we produce productive people, then productive people will not commit crimes, and because they don't commit crimes, then Jefferson County will be what? A safer place for all of us. And so that's our programs that we have. Now we have someone here from our Spindletop program. We have Deputy Hinton, and Deputy Hinton is going to talk to you and tell you about the program that we have, that they have to offer. And if you desire to participate, just let him know, just let them know, and they'll be happy to assist you. At this time, I now present to you Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy with Jefferson County Sheriff's Office. We've teamed up with Spindletop, and we have a couple qualified mental health professionals back here in the office with me. The reason the judge has allowed us into the courtroom is because because he wants us to help y'all, to advocate for y'all, and that's what we want to do. What we found is sometimes people who are in and out of the jail or in and out of the court system have underlying factors such as mental health issues or substance use disorders. And so if that applies to you, we want to provide services, options, and opportunities for you to try to fix those things so we can get you out of the jail, get you out of the court system, and get you productive in life. Does anyone have any questions?
Don't have anything in Houston.
No, but we do have some contacts in Houston. We can forward that to you. Yes, sir.
I've been under inmate supervision since I was 12 years old, right?
Yes, sir.
They said they lost me in the system 3 times. I have been taking meds almost 6 years. Almost 7 years I haven't took no medication. I've been under inmate Spindletop supervision since I was 12 years old. But they lost me in the system 3 times. I haven't took no, I've been to the state jail. Glad I guess I never took no mental health meds there. I've been to the county jail numerous of times. I never took medications in jail. I never had no evaluations with my counselor. I never got a chance to talk about it with inmates more. They said they lose me in the system every time.
Well, let me correct that today. We're going to speak to you, okay?
Yes, sir.
We're going to talk to you at length, and we're going to work with you through that. That's another thing we do is we advocate through the system because sometimes it can be complicated. So we want to help you get through that and jump over some of these obstacles to get you the assistance that you want, that's beneficial for you in your particular situation.
I just wanted to ask that. That's awesome.
Excellent. So I'm going to be going around and talking as the court proceeding goes on. I'll be going around and talking to each and every one of you. If you want to talk, we can go back here in the back room, we can talk, and whatever we can do to help you, that's what we're here for.
Okay.
Thank you, Your Honor.
All right, thank you, Deputy Henry. Now, ladies and gentlemen, as I said earlier, we don't have court as usual, we have unusual court. And as I said, it's not because we're different, but we're trying to make a difference in the lives of the individuals that come before the court, and we're trying to make a difference in Jefferson County. Now, also, we in County Court at Law number 2, we don't just arrest the problem, we address the problem. And so if you have any of these issues, we have individuals who can assist you and address whatever the problems that you have. Now, at this time, what I should mention is earlier you was handed out some forms. Now, when I started off, I went through that form by telling you that as a defendant in the criminal case, you have 3 options. And do you see that on the form? Now, if you, at the bottom of this document, if you want to reset this case to hire an attorney, you will put your initials on the first line to the left. If you have hired an attorney, you'll put your initial on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed counsel, then you'll put your initials on the third line to the left. If you already have a court-appointed or counsel appointed, then you will put your initial on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and to represent yourself, then you will put your initials on the fifth line to the left. Now, those of you who are applying for a court-appointed attorney, you would have to fill out a financial questionnaire, and we have those here. And we have someone who will assist you with filling out the questionnaire. If you are representing yourself, then you will have to fill out the second page of that form where it says waiver, and it reads, waiver of counsel for purposes of entering a guilty plea or proceeding to trial. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this second day of March of 2021 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that's your desire, you will sign where it says defendant, and you will put today's date, which is March 2nd of 2021. And we'll have someone that will pick up those forms from you, and then we'll put you into various categories as to whether or not you want to hire, whether or not you want to see if you qualify for a court-appointed attorney, or whether or not you want to represent yourself.